Mr. Zhulkarnain Abdul Rahim.
Madam Deputy Speaker, I stand in support of the bill. Digital technology has permeated our lives. It has a deep impact on how we learn, how we do business, and how we interact with one another. However, because of the cloak of anonymity, the online world rears its ugly side through online harms. Maintaining safety online is not just the responsibility of the individual or the government, but all stakeholders involved. In this regard, many felt stricter enforcement of relevant laws can be effective to combat or reduce online harms. Many also felt that technology companies and platforms must lead the way in tackling this issue alongside the government and us fellow Singaporeans. It is thus timely that we have this bill to further help us safeguard Singaporeans against online harms. Last week, my firm organized its annual thought leadership platform, the Denton's Rodak Dialogue 2022, themed Building a Safe and Inclusive Digital World Together, Vision and Transformation. During the keynote speech, Minister Josephine Teo explained Singapore's approach in regulation towards digital safety and inclusion by ensuring what she describes as the 3 A's. First, accretive, building each step or measure one after the other in a calibrated approach. Second, agglomerate, pulling in partners and groups in our collective endeavor. Third, agile, being able to adapt through different emerging technology or disruptions. To borrow from Bond's credit rating parlance, that to me is AAA rated approach, sound and sensible. In dealing with online harms, it is important to take a calibrated and multi-stakeholder approach while keeping a close eye on emerging technologies such as Web 3.0 and the metaverse. Although the bill is focused on platform and service providers, there is also a need to focus on the users, particularly the victims of online harms. In June 2021, I started an initiative called Defence Guild SG, a collaborative group of lawyers providing pro bono assistance to victims of online abuse or harm. We now have over 20 lawyers who volunteer pro bono to assist or advise victims who face sexual harassment or online harms. The bulk of the cases they face are time-sensitive, given the viral nature of the harmful online content, but most importantly, they are emotionally draining, and usually it is time and cost-consuming for victims to seek redress. Following this initiative, together with other PAP MPs like Ms. Henny So and Ms. Nadia Ahmad Samdin, we spearheaded the formation of a resource toolkit to combat online harms at the PAP Women's Wing International Women's Day celebration in March this year. And in September this year, with the help of pro bono lawyers, social workers, and counselors, we ran a workshop for close to 70 activists across various PAP branches on a practical walkthrough of the resource toolkit. This is to support residents during Meet the People sessions or any of our other activities. Notwithstanding all of our efforts, according to a recent survey, almost 57% do not know what are the legal redress or help that they can get when faced with online harms personally. Hence, raising awareness and empowerment is a continuing endeavor. In this regard, I have 3 suggestions. First, to provide legal pro bono advice under the Legal Aid Bureau for individuals facing online harms, much like what Defence Guild SG is doing for victims currently. Second, to standardize the ease of reporting of online harms across all platforms. Third, to seek platform and broadcasting service providers to be included in public awareness campaigns on eradicating online harms. In Malay, please, Madam Deputy Speaker. Pada Jun 2021, saya memulakan inisiatif yang dipanggil Defence Guild SG. Ini setelah tersebarnya isu gangguan terhadap 17 ustazah tempatan yang menjadi mangsa tinjauan lucah dalam talian. Isu ini menyedarkan ramai anggota masyarakat kita akan ancaman bahaya dalam talian atau online harms. Lebih 20 peguam berbilang bangsa dan agama terdiri daripada peguam veteran dan peguam muda daripada rangkaian peguam di M Kuasa 3. Mereka bergabung untuk menyediakan nasihat guaman kepada mangsa-mangsa gangguan dalam talian. Sebahagian besar kes yang mereka hadapi adalah sensitif dan ramai antara masyarakat kita yang tidak maklum akan bantuan yang ada serta hak mereka. Namun, perlindungan ini tidak dapat dibina tanpa kerjasama semua pihak daripada pemerintah, individu dan syarikat teknologi atau pembekal khidmat dalam talian. Justru, rang undang-undang ini meletakkan tanggungjawab kepada penyedia perkhidmatan untuk menyekat kandungan dalam talian yang boleh menyebabkan kemudaratan seperti kandungan berbaur, ekstremis, keganasan dan yang menjejaskan masyarakat kita yang berbilang kaum dan agama. Oleh itu, saya bersetuju dengan rang undang-undang ini. Madam Deputy Speaker, I now move away from the individual and on to the service providers, the focus of this bill. I have several clarifications. Firstly, I would like to clarify on the definitions used in the bill. Second set of clarifications relate to the mechanism of the takedown and defense available. Lastly, I have some clarifications on the code of practice proposed. First, on the definitions. In determining whether a broadcasting service is private or domestic, the new Section 2, Subsection 3 of the Broadcasting Act gave regard to certain factors, and I will touch on two of them. Firstly, on the number of individuals in Singapore who are able to access the content. The clause itself does not state a guidance on the actual number as a threshold. In this regard, may I ask, what would the threshold be? Should it be a percentage of entire users of the service who are in Singapore? Some clarity in this regard would be helpful. Secondly, on the restrictions on who may access the content. Would content on accounts which are accessible through friends or restricted followers be considered private or domestic nature? Next, in respect of the new clause 45D, which sets out the definition of egregious content, I have a few questions. First, what is meant by content that advocates or instructs? Would the ministry consider content to be harmful by looking objectively at its impact on our society, even though the content itself may not provide a clear set of instructions or advocate a certain position? Second, on resources, may I ask, who will be the enforcement agency for this? And would there be a dedicated team to regulate such behavior? And if so, how are we sufficiently resourced for this? For example, in Australia, the Department of Home Affairs has a dedicated team to find content on social media sites that promote hate, incite violence, or point to terrorist propaganda. The team has a budget of around Australian 3 million. It is a resource-intensive endeavor, and if we rely on self-reporting by individuals or self-regulation by providers, there may be many instances of online harms that fall through the crack. Thirdly, I note that certain categories of harms are expressly stated in the bill. May I ask, what about issues relating to drug abuse or any other activities that are illegal or against our social norms? Would this be considered harmful content as well? May I suggest that certain discretion be given to include any future definition of harmful content? My next clarifications are on the mechanism. I welcome the takedown or disabling order under Clause 45H and the blocking order under Clause 45I. In particular, the new Clause 45E makes it an offense of not stopping egregious content on online communication service. There is also a defense available to service providers in not complying with the order if it was not reasonably practicable to do more than what was in fact done, or if there was no better practicable means than what was in fact used. However, may I ask what is meant by reasonably practicable? Would the costs or expenses involved in complying with such order be a relevant factor? Likewise, what about actual or consequential loss that the party may suffer when complying with such duty? I would suggest that such costs, expenses, and losses should not be relevant factors. This is because economic losses or ramifications should not be placed on equal importance footing with online harms that have debilitating and irreversible effect on our society and individuals. Nevertheless, I would welcome Minister's clarifications in this regard. Next, in relation to the immunity against criminal or civil liability when complying with the orders under Clause 45J, would this apply to civil liability brought by parties from outside the jurisdiction as well? I understand and fully appreciate that our laws may not have extraterritorial effect in this respect. I'm fully aware that the current bill, as proposed, was done after extensive consultation with service providers and platforms, and that they are supportive of such proposals. Other jurisdictions have also passed similar legislation to safeguard against online harms. Perhaps the Ministry can also explore reciprocal immunity provisions with other like-minded jurisdictions in the future. This would help harmonize and set an international standard for compliance of cross-border directions in the future. My next clarification is in relation to Clause 45H, subsection 1D, on the period of takedown notice. Can we consider a fixed period? For example, Germany's similar law provides for a 24-hour requirement for takedown. This reflects the imminent risk of such online harms. If there is a standard fixed period by legislation, it will lead to a reasonable expectation or standard within the industry for compliance, and sufficient company internal compliance processes can be put in place to meet with such expectations. Alternatively, perhaps Minister can clarify what is the estimated period that is envisaged for a typical direction or order. Lastly, may I clarify what is meant by Clause 45H, subsection 2B, that a requirement must not require the doing of anything with respect to the provision of an online communication service to the whole or part of any area in Singapore. Perhaps can Minister provide an example for this? Finally, Madam Deputy Speaker, in relation to the Code of Practice, I welcome such Code of Practice. I understand that the Code can be revised or amended pursuant to a process that to be followed, which allows for future flexibility and adaptability. My question is, given the fluidity and dynamic nature of our digital ecosystem, would the Code be able to keep up with the changes brought upon by the rapid changes of technology? I note that there is a process before a change in code can be made, as envisaged at Clause 45L. However, how long would that take? Would the Minister consider the formation of a council to formulate and update the code regularly to keep up with technology trends? Such council can comprise of service providers, regulators, important law enforcement, or community stakeholders. In conclusion, and most importantly, digital safety is the responsibility of everyone. Notwithstanding the above clarifications, Madam Deputy Speaker, I stand in support of the bill. Thank you.